We do have time for questions from the floor. If anybody would like to ask any member of the panel here any questions. Yes, sir. State who you are. Step up to the microphone.
My name is Ron Goldbrenner. You mentioned...
Is that on? I don't think so.
You mentioned before that the U.S. courts were a little bit more friendly toward the museums than the claimants. Can you tell us what the legal theories are that they mostly use to... can you tell us what the legal theories are that they use to support denying restitution?
Well, very often the cases are resolved on the basis of technical defenses. The statute of limitations, at least up until the time of the HERE Act, was the basic tool that possessors, whether they're museums or not, used to knock out these cases. The doctrine of laches in certain states was used. That's an equitable doctrine that most of you know, I guess, that even though the statute hasn't run, there's interminable delay to the prejudice of the defendant. And other technical defenses were very often asserted. But though the statute of limitations is one of the few issues we won on in the Good Sticker case, the fact is that in the end, it was decided on the active state doctrine. So different theories are used by different courts. And when I say, I'm not condemning any court in the United States, and I'm not criticizing them, except I do believe that there's a philosophy in the United States. We weren't there. We weren't the bad guys. We weren't the people that took it. And when it gets here, you know, it took a long trip, and it's not so fair to punish the people that are here. But on the other hand, we believe that it was stolen properly. Indeed, as the worst thefts in the history of mankind, and the special rule has to apply.
Yeah, I would say that museums suing Jews is a really disgraceful thing. And the history books now contain those cases, and they're good law in their jurisdictions. Detroit Institute of the Arts and Toledo Museum suing the same family in different jurisdictions on successive days and getting their claims, their counterclaims dismissed on a Rule 12b6 motion, which cut off all discovery to the Jewish families, was absolutely horrific. It doesn't make any sense. It doesn't make sense under the Federal Rules of Civil Procedure. It doesn't make sense under what's right and how our courts should be used, and it doesn't serve justice or the truth. And those museums that are hanging those paintings now should really be ashamed of themselves. And I went to Toledo, I went to their law school, and I gave my lecture. There were people shouting at me, there were people crying, they're like, who was the judge? And I've been very, very critical of the courts, unlike Larry.
Bill?
Yeah, can I you guys are giving laches a bad rap. I've used it, or I've seen it used, I used it and I've seen it used in the antiquities context in several declaratory judgment actions against source nations, declaratory judgment actions to prove title. And, you know, it's a hard thing when a bona fide purchaser takes in the stream of commerce and a country like whoever, you know, whatever country, Lebanon, Syria, Turkey, Egypt, knew about a theft, sat on its hands, didn't report it to the art loss register, did nothing, allowed the work to circulate in the stream of commerce through successive owners who successively prejudiced themselves due to the inaction and, in essence, negligence of the source country. So you're starting to see an offensive use now of laches in the antiquities context.
Nobody up on this panel is from a museum. Some have represented museums, but I think that perhaps if there is somebody in the audience here who could speak for the museum, it might be a good idea, because one sees all sorts of incentives on the part of people with questionable art to give the art to the museum and take a whopping tax deduction, which is may or may not be challenged by the IRS. And the museum sits there with a beautiful Picasso that Mr. Lefman had to part with for $12,000 in order to get out of danger. And there seems to be, in a very broad sense, a feeling of unjust enrichment on the part of the recipients of this art and the people who have it now. And I'm speaking in very broad brush strokes right now. I'm not talking in terms of any specific application of legal doctrine. But maybe there is a case for the museums. And if there is, maybe either somebody could speak up on behalf of a museum, or maybe a lawyer who once represented one at least could advance it. Yes.
My name is Sharon Flescher, General Counsel of the Metropolitan Museum of Art.
Perfect. Well, we've got the right person, the General Counsel for the Metropolitan Museum of Art. Good.
I'm not going to speak in detail about the actor. That is pending in court. Larry has recommended you read the complaint. I ask that you also read our answer and follow the case. Sure.
You can take that microphone off.
The Lefman case that Larry Kaye mentioned. I won't be able to speak about that in detail tonight, but I just recommend that if you read the complaint, and of course on a motion to dismiss, everything needs to be assumed, all the facts in that. Leffman. Of course, on a motion to dismiss, you assume the facts as they are. So that is the current posture of the case.
Could you speak also to the question of what the museum does to determine provenance before you accept art?
Yeah, I'd love to go back to the premise a little bit of the roles of museums in these cases, because there was a slide that showed the principles that the museum community has adopted. And the museum community pledged to Congress and continues to be actively committed to researching the provenance of the works in our collections. We put them online, we invest time and resources, and this is a search, a quest for knowledge that is foundational to the museum community. It existed before the Holocaust issues. It will be with us long after those issues. With the archives that opened, more resources were available for this research, and it's an ongoing effort. And as suggested on the panel, the search for the facts, the search for the truth is a commitment that we have all made. The principles that we adopted state that if a work was looted from a Holocaust victim, we are committed to returning it. I think what wasn't perhaps mentioned tonight is that there are multiple situations that have not gone to court where museums faced with information that they discovered on their own initiative and went to a claimant, or that a lawyer or a family member brought to them, has resulted in the return of works of art. And those cases are all listed on the AMD website. I believe they're up to 45 or 50 situations where the works have gone back. The ones that end up in court, I can't speak for each museum, each of the facts are individual or different. I believe the common thread is that in those cases, the museums do not believe the work was looted from a Holocaust victim, that there are disputes as to the facts. Once in a court, some of the decisions have been procedural rather than substantive. So if that's helpful, that's how we approach them. Thank you.
Does anybody else have any other questions or thoughts?
Judge, I represented the Pergamon Museum in recovering an amulet, and we took it up to the New York Court of Appeals and won. And the interesting thing there was the museum was accused of not warning the world that it had lost this object. But it was a unique object. It was in the museum's collection, and it was the government, and it had documented that work in its collection. So sometimes even when there is inaction, the world can still be on notice.
Good, thank you. We are now, yes, did somebody?
I just wondered with the advent of the internet since '98 and the opening of the archives and the declassification of a lot of this material from the Nazi era, including work of the government, do you anticipate that there is going to be additional cases as people, in the 50s or 60s, they may not have been aware further additional claims.
Well, it is already, and there was a meeting before the Holocaust Conference in '98 of art experts. Monica was there, I was there, other people in this room were there, and somebody said, I think it was the Art Laws Register, well, this should take about 3 or 4 years, and then we can wrap it up. And obviously, that hasn't happened, and I think it's going to continue too as more information becomes available, and it is every day.
Right, if I could just add, that's one of the biggest challenges for Christie's and for us. New information comes out all the time, and more information is becoming accessible regularly. None of this information has been centralized yet to a huge degree. We're getting there, but new information surfaces all the time. And one of the biggest challenges is we can only do the best due diligence we can at one point in time when a work is consigned to us. But new information might come out, a year from now, or a book is published about a particular collector that might have suffered during World War II, and then all of a sudden the family sees that they have a potential claim. So new information is coming. It's a moving target. I mean, the landscape keeps shifting, and there is more and more information coming out.
Yes, we'll take this. I think it'll be our last question.
I've been working a little bit on the Jewish Cultural Reconstruction, which was an organization that gained legal standing to become the trustee mainly of books, but also of Judaica and other cultural objects when there were no living, that is to say, surviving parties to claim looted objects. And I'm wondering, as we have sort of the timeline of archives becoming more and more accessible, but the survivors and heirs becoming less able to exact a claim, whether there is the prospect of any similar organization that is similar to the Jewish Cultural Reconstruction that could become the trustee, the legal trustee or legal heir of items on behalf of the Jewish community, if there is no surviving heir to exert a claim, if a claim can be proven.
I'm not sure I understand completely the question, because the issue has come up many times, what's going to happen with the orphaned objects, where we just don't know, the airless objects, where we don't know where the families are. There may not be any heirs. Many years ago, Christie's actually was involved in the Mauerbach sale, where money was given to the Viennese Jewish community from the proceeds of the sale. But then later, there was some criticism about that, because it was before a lot of the research was done, and some of the works actually could be traced to families later on. Now there's some suggestion that the works go to Israel, but I think there's a lot of dispute. I don't know that there's any agreement as to what should happen to these airless objects. Maybe Monica has some more to add on that.
I mean, I just think that the discussion is sort of premature. I mean, I think that we still, I think there's still a lot of work to be done, and a lot of research and materials that are still going to be coming out. And I think it's just too early to sort of declare what might be airless or not. That was the issue with Mauerbach. I mean, Christie's did a sale of property that was found in salt mine. It was in '96. And, it turned out again that there wasn't a lot of accessible information. And later on, you could actually trace some of the works that were sold to families.
There's if I may.
Quickly, yeah.
Dr. Wesley Fisher of the Jewish Claims Conference has been really active in holding countries' feet to the fire in terms of doing the right thing. The JUST Act, which was signed by President Trump in 2017, requires the U.S. State Department to report on the activities of various countries on this issue. And I think the report should come out this September. So that's a diplomatic effort that is ongoing, and Ambassador Eisenstadt is very active with that.
Well, I would like to thank our panel for an excellent presentation.